This is the first in a series of interviews throughout the nation between National Defense Counsel and members of Berkeley Med's claim management team.
So what I would like to do is visit with you a few minutes, John, about your practice in defending against the reptile strategy. It seems to me there's several tactics, someone of your experience, that can take against this reptile strategy. What have you found that's been successful in combating it?
Let's start with first things first. First of all is recognizing that it's out there. Even in the discovery phase, when you're preparing your nurses for deposition, let's say you've got a nurse for deposition. Nurses, first of all, immediately, you have to think of who they are. They're not people who have chosen to be public speakers. They're in a situation where they're typically faced with an authoritative figure who's directing their care, a doctor. And they're usually somebody whose first question when something happens is, what did we do wrong? Because they're trying to second guess themselves to be better every time. If you take that sort of person, they're ideally set to be victimized by the reptile theory. Because that person, if you say something like, well, shouldn't you keep your patients safe at all times? Well, yes. Of course I should keep my patients safe. If something happens to them, we start questioning what we did. Well, the truth of the matter is we can't. That's not the legal standard. We don't keep everybody safe from every potential harm in the world. If we were going to keep them safe, then we would go disarm North Korea from nuclear weapons. And we can't go that far. And that's absurd, but that's the same absurdity that the plaintiffs take in trying to prove what actions we should have taken in the medical world. So first of all, you instruct those nurses and you let them know that this is coming. You practice it with them when you're preparing them for their depositions. You let them understand that this person is not out to find what the legal standard is, what a reasonable nurse would do under the circumstances, but instead is trying to some absolute rule that you can't meet in hopes that you'll second guess yourself and say you violated it. So I think you've got to start with first things first, right in the discovery period, as you're starting to prepare to defend the lawsuit.
So if you're starting to see it that early in discovery, what you're telling me is there needs to be an educational process with the defense counsel that may be handling the case for the hospital, as well as with the nurses or the parties being deposed, to help them understand that the line of questioning is going to be more about safety guidelines, as opposed to the standard of care, which is the legal requirement that they have to prove.
Yeah, just to take off what you said, I think what you've got to tell them is that's where the plaintiffs is wanting it to go, but that's not where we're going to allow it to go. And you've got to give them techniques to stop it from going there early.
So once you get through the discovery phase and you protect these nurses or hospital administrators in depositions and you help them understand this whole approach, as you get closer to trial, what are some of the tactics that you can use to continue to combat this reptile strategy?
Depending on how obvious they've been in the discovery phase, the plaintiffs very well may have asked questions or done actions in the discovery phase that tips their cards about where they're going. And you can go ahead and file motions in limine. In other words, if they've asked questions of your experts, would this keep the patient safer? You might file a motion in limine to keep them from being able to use that question in the trial as a potential cross-examination of your expert, because that's not the legal standard. You point out to the judge, it's not whether or not you could keep them safer, Judge. That's not the legal standard. The legal standard is whether or not this conduct was reasonable. And so you can't impeach somebody on a reasonable standard when you've asked them this vague, safer question. And so it's really to start, even from that phase, focusing on those questions. Now, that depends on where you are, what jurisdiction you're in. It depends on what judge you have. It depends on the status. You still, as a lawyer, have to make judgments when to use these individual tools. but you ought to have every individual tool being considered in every case.
In your prior experience with the Reptile strategy, did you use motion in limine? And let me have a follow-up question to that too for our clients. In the event that some do not know what a motion in limine is, can you specifically explain what a motion in limine is and the thought process behind why you're using that?
Sure. A motion in limine is really just a pleading you file, usually 30 days before the case goes to trial, in which there's some particular piece of evidence that you think is going to be used in a way or attempted to be used in a way by the plaintiff's attorney that is contrary to the law. And so instead of waiting until the trial when that question is asked and then standing up and objecting, which is what we do a lot of times for a lot of different reasons, if it's something that we already anticipate that we know they're going to ask, then we want to try to stop it so that really, literally the horse never gets out of the barn. They never get that question. There's nothing worse than, did you kill your wife? Objection, Your Honor. Jury disregard that question. They're all wondering why they asked the question, did you kill your wife? So it is an important issue if it's an important issue that you see coming, this way you stop it from ever being heard by the jury. Now, and you'll hear defense lawyers all the time, and believe me, I know this is a difficult world. The judge will never do this, the judge will never do that. Well, let me tell you, the judge will never do it if you don't ask. It is amazing to me how many times we prejudge judges to say that they aren't smart enough to figure out what the law is and apply it. We ought to give them a chance to figure out the law and apply it. We ought to aggressively pursue this strategy at every stage.
It seems to me, John, from listening to you discuss it and talk about the Reptile strategy, that where you have a unique opportunity to maximize your chances to rebut this theory would be during jury selection, and that period of time that you have to really diffuse this strategy and to visit with jurors and to educate them on the legal standard. Do you find that you're able to use this process or this opportunity to combat it in jury selection?
In every case, you ought to be combating this strategy in jury selection if you have any sense that it's going to come into your case. And sometimes you ought to do it even if it doesn't, you don't see it coming into your case, because it's still a good foundation to get the jury back to the law. You do that by getting the jury where you can and it depends on your jurisdiction and how far you can go, but getting the jury to understand that there's certain legal principles that guide conduct. And you want to make sure that you understand that what we're here about is not whether or not a child should be taken care of. We're here about whether this person's conduct justifies that person being responsible to take care of. And in order to do that, there has to be we all want to be judged fairly. And the jury, you start playing the jury's emotion the other way. You bring them back to saying, well, I would want to be judged fairly. And you want to be judged fairly by set rules that have rational and the ability to actually comply with. Thus, our law is pretty straightforward that way, reasonable conduct. So you start working the jury to understand that there are set reasonable rules, and it's not absolute rules that the plaintiff's lawyer is going to use. It's these reasonable rules that they have to apply in the trial. And, in fact, the judge is going to tell them to do that at the end when he charges them the law. We go ahead and let them know that, even in voir dire.
Why do you think it's been so successful for the plaintiffs?
I think it's easy. I think there's really three things. Number one, it's very easy for jurors to get their minds around yes or no. These are complex cases, and if you can help a juror, and that's what the plaintiff's lawyer is trying to do, help the juror decide the case for him. If you can help the juror see, well, you can just decide yes or no, and then you don't have to worry about all of this other stuff. Do you feel like you should be protected from this? And if you do, then you decide for the plaintiffs. So I think because of the simplicity of it, I think it's got that attraction. I think the other is defense lawyers, especially when they haven't tried catastrophic cases frequently, it's an unusual experience, and we tend to get complacent in the rules. We think, well, the world is like it always is. We do A, B, and C. Well, sometimes if they're telling the jury that A, B, and C don't matter, what really matters is this issue down here, and you're not addressing that issue, then you're not talking the same language to the jury that the plaintiff is. And I think it's very important that you have to be proactive in challenging the plaintiff's use of this strategy and challenging the jury to do what they did, to the point that in voir dire, you make the jury promise that they're going to decide the case based on the law, and we're allowed to in a particular jurisdiction. You get them to commit to those principles of law, such as burden of proof, such as the standard of care, that you're going to have them to do. And then I think the last reason that it is successful is that it's very simple in terms of emotion. Not only is it a yes or no question, but they're almost violating the golden rule. What they're trying to do is have the jury put themselves in the position of the plaintiffs and try to decide the case based on how your personal emotions are. And that's a difficult battle not to fight. If you allow one side to win the emotional heart of a jury and you aren't coming back and trying to capture that emotional heart back, then it doesn't matter what the facts, logic, and science is. The jury's going to go where they're led. And so I think for those three reasons, the simplicity of it overall and then the consequences is why we're seeing this be prevalent.
John, thank you for your time visiting with us today about this new reptile strategy. We really appreciate it, and we look forward to working with you in the future.
Well, it's a pleasure. Appreciate Berkeley Med coming to our national office, and look forward to working with you guys to defeat these reptiles in the future.
All right.